This meeting is recorded. There we go. Now we're back on track. Okay, so my contact information is up on the screen. You're welcome to reach out to me. I try to be available. I'm telecommuting right now. Sometimes I work in the office, sometimes I'm working from home, but you can always call, either leave a message with our wonderful secretary, Candace Watson, or you may be able to get through to me directly, but don't hesitate to leave a message. You're also always welcome to email me. Sometimes it's easier just to send a quick note and get an answer that way. So our phone number's there, our website's there, email address is there. Please feel free to use any of those mechanisms for contacting our office. The Committee on Open Government is administratively housed within the New York State Department of State. We are a quasi-independent agency, but the Department of State does provide support services to our office. That's where our offices are. It's where it provides all the administrative support for the Committee on Open Government. And if you're looking for our website, the Committee on Open Government website is currently housed also on the Department of State website. Another way to find us is also just to Google the acronym COOG, C-O-O-G. That's an easy way to find us. We're usually one of the first results that comes up when you search that. The New York State Freedom of Information Law is codified in Public Officers Law, Article 6, Sections 84 through 90. That's great for all the lawyers out there, but for any of you who just want the easy way, go to our website, go to the Committee on Open Government's website. We have copies of both the Freedom of Information Law and the Open Meetings Law right up on our website. And I'll take this quick moment to sell that I do plan to do these on a repeating basis, these programs. My hope is to alternate every month between Freedom of Information Law presentations and Open Meetings Law presentations. So my thought is early next January, I will do a program on the New York State Open Meetings Law. So for those of you that are interested in that as well, please keep an eye on our website and I'll get something posted. It'll be a very similar format to that. And again, I will just continue to do these as long as I think that people are interested. I'll continue offering these programs on a monthly basis, alternating between FOIL and the Open Meetings Law. Here's a quick look at what our website looks like. So from the home page, I just want to point out a couple things that you can access from our home page. On the right-hand side, you'll see there's news items. And this image is a little dated, but we try to keep things of general interest, things that are new that have come out. Maybe perhaps in the past, obviously the past 8-9 months, there's been a lot going on with COVID restrictions and how that impacts both FOIL and the Open Meetings Law. If we have any guidance to provide on those types of issues, that will appear there. We put our meeting notices there. The meetings of the actual Committee on Open Government goes there. And any information about the training that I'm offering will also be on the news section. At the top of the screen, you'll see headings. For example, there's a section, I would like to. If you drop down on that, you'll see there's options for, I would like to submit a FOIL request. How do I do that? I would like to view videos of the meetings of the Committee on Open Government. How do I do that? Under the Freedom of Information Law tab, there's a copy of the statute, of the regulations, of model regulations that your agency can use for your own Freedom of Information Law policy or regulations. It also has access under that tab to Freedom of Information Law advisory opinions and case law summaries. Under the Open Meetings Law, it's very similar, copy of the statute, copy of model regulations for use of cameras during meetings, broadcasting during meetings. We have some model guidelines, policies. In that section, we have advisory opinions and case law summaries. Under publications, we have a great publication called Your Right to Know. It is a brief overview of both Freedom of Information Law and the Open Meetings Law, so it's a good starting point for anyone that really has never dealt with these statutes at all. The publication Your Right to Know is a good place to start. I'll briefly mention the Personal Privacy Protection Law, but I'm going to guess that 99% of you do not care about the Personal Privacy Protection Law because it only governs records maintained by state agencies. So if you are a representative of a local government, if you're a town clerk, village clerk, whatever it may be, the Personal Privacy Protection Law does not govern records maintained by your municipality, so you don't really need to worry about it. But if you ever have questions, if you do work for a state agency, or if you have questions just in your personal capacity about the Personal Privacy Protection Law, that is something we can also assist you with. So in 1974, the original Freedom of Information Law was passed. It's fairly limited in scope in 1974, though. You only had access to 9 categories of records. The law said, here's what you can have, that's it, nothing else, end of story. Nobody really liked that version of the statute very much, and it didn't last long. And in 1978, the original version was repealed, and it was replaced with what is essentially the current version of the statute. And that current version of the statute is based on a presumption of access. So when an agency receives a Freedom of Information Law request in New York State, it should start with the assumption that all government records are subject to FOIL disclosure. All government records are FOILable, so to speak. That's a question I get a lot. Is this record FOILable? Can I FOIL that? Do I have to give this out under FOIL? Well, the first thing you think of is it a record that you maintain? Is it a record that you possess? I'm going to go into a little bit more detail about how the Freedom of Information Law defines record, but there's that presumption of access that all records maintained by a government agency are subject to FOIL disclosure. That doesn't mean that all records need to be disclosed, but you at least need to consider and determine whether those records, whether you possess the records, and whether there's any permissible ground for denial of access. If there's no permissible ground for denial of access, then the likelihood is those records are going to need to be disclosed. Who is covered by FOIL? FOIL governs access to agency records, and the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof. That's a lot of information, but I think most of us understand the basics. Of course, state agencies are subject to FOIL. Local levels of government such as county, city, town, village, not fire departments, I'm blanking on the words, districts, fire districts, school districts, public libraries. There's many, many levels. There's thousands of units of local government across the state of New York. And if you have a question, I mean, most of you who are here today, if you work for local government, you already know that you're an agency subject to FOIL. If there's ever a question of if you are attempting to obtain records from an entity that you believe may be a public entity that's subject to FOIL, but you're not sure, that's something that you can contact our office with, and we can discuss with you. You'll notice that I highlight here that what's exempt from the definition of agency is the judiciary and the state legislature. So in New York State, the courts, access to court records is not governed by the Freedom of Information Law. It's governed by other statutes. That's not to say that court records may not be publicly available to a large extent. It's just that access to those records is not governed by the Freedom of Information Law. The state legislature is not considered an agency as the term is defined under FOIL. It is records maintained by the state legislature are available to a limited extent under FOIL. You'll recall a few minutes ago, I mentioned the original 1974 version of the Freedom of Information Law that talks about how there was a list of records, 9 categories of records that were available. Well, the same is still true of the state legislature. The Freedom of Information Law says these are the types of records that you can obtain from the state legislature, and everything else is, they're not obligated to provide under FOIL. The definition of record under the Freedom of Information Law is very broad. Sometimes I get the question, well, you know, someone from a government agency will contact me and say, well, someone is asking for these email communications, but these aren't communications that we're required to keep under the record retention and disposition schedule set out by the New York State Archives. We should all keep in mind that the definition of record under the Freedom of Information Law and the definition of record put out by the New York State Archives is very different. Freedom of Information Law definition is significantly broader. This any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. It's paper, it's data, it's email, it's video, it's audio, it's, again, data maintained in a database. It is very, very broad, any information in any physical form whatsoever. Those are records that are subject to FOIL. Under the Freedom of Information Law, you are not required to create a record. That does not mean, so for example, when I say you're not required to create a record, if someone sends you a request for information, for example, they're asking questions, someone sends a letter or an email asking you questions about how your agency functions, or basically asking you to provide information that does not exist in record form, or perhaps is asking your agency to explain why they took certain actions. The Freedom of Information Law is really more, it's an access to record statute. So freedom of information is somewhat of a misnomer because it's not about all information, it's about information that's maintained in record form. So an agency is not required to create a new record in response to a FOIL request. You're not required to answer questions. You're not required to provide access to records that do not exist in record form. This, of course, does not mean that an agency is not required to make copies of records or to convert them to a preferred format if possible. So, for example, if you have paper records and someone is asking you to scan them into a PDF or a TIFF or whatever it may be and email it to them, that's not creating a new record. That's just making a copy of an existing record. Extracting data from a database is not creating a new record. Redacting a record is not creating a new record. It is just pulling information, so to speak, out of an existing record. That's not creating a new record. There are 3 exceptions to an agency's, the rule that an agency is not required to create a new record. The first is that under the Freedom of Information Law, all agencies are required to maintain a record of how each member of a public body that the agency houses voted. This is a little bit interesting. I'm not really sure why at some point this provision in FOIL wasn't sort of moved over to the Open Meetings Law, but it's not. It exists here in the Freedom of Information Law. So while under the Open Meetings Law, there's an obligation to prepare minutes of open meetings, and those minutes are supposed to reflect records and summaries of any motions, proposals, resolutions, and the vote thereon. The Open Meetings Law doesn't actually require a public body to maintain a record of how each individual member voted. However, the Freedom of Information Law does contain that obligation. So my advice is always, why have 2 records? Just include that information in your minutes. Your minutes, to make things easier, if your minutes reflect how each member voted, for example, even if it's, you know, the vote was unanimous, well, that's clearly an indication of how each member voted. But if there's any sort of split, if you have a 5-member board and 3 members voted in favor and 2 voted against, your minutes need to reflect how each individual board member voted. Or if you really want to make things complicated, you can have a separate record that reflects that information, but it has to be maintained somewhere under this statutory obligation under the Freedom of Information Law. The second type of record that the Freedom of Information Law requires every agency to maintain, a list that contains the name, public office address, title, and salary of each of its employees and officials. So that's information that every agency should possess, and it should be made available upon request. The last is a subject matter. The law says that every agency should maintain and make available a reasonably detailed subject matter list. My advice, particularly for local municipalities, perhaps not as much for state agencies, because I'll explain why in a second, but for many local government agencies, the best thing and the easiest thing for you to do to comply with this requirement is to adopt the record retention and disposition schedule established by the New York State Archives as your subject matter list, because the two are going to match up really nicely. So if your municipality would like to, it can simply just make a motion and adopt this, the record retention and disposition schedule established by the New York State Archives as your reasonably detailed subject matter list. I'll take this moment to point out that I believe that the record retention schedule has changed a little bit recently. Instead of having multiple schedules for different types of local government, now there's just one single retention schedule. So that may be something your board might want to consider, just updating and adopting the new schedule as its subject matter list. For state agencies, there's only one subject matter list for every single state agency, and of course all state agencies do a myriad of different things. So while the record retention and disposition schedule might be a good jumping off point, there's also going to be many other records that should be on that list. So the list probably needs to be a little more detailed than the retention and disposition schedule put out by the archives. In terms of, I mentioned this briefly before, but there's a distinction between creating a record and preparing a copy of a record. There's a provision of the statute of FOIL that states an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. Someone had posed a question to me earlier this week about whether, for example, if someone would like the records provided to them in electronic format on an electronic storage device, but it's easier for the agency to, for example, upload them onto a online transfer service. Not being very tech savvy here, but I think many of you probably have an idea of what I'm talking about. Like, you know, there's Dropbox, things of that nature, where you upload the document, somebody opens it on the other side. I think it depends on what the requester wants. If the requester doesn't feel comfortable logging on to an online transfer service, or would prefer not to have to create an account or whatever it may be, I don't think they should be obligated to do so. If they're willing to pay your agency for the cost of the storage device, I think you should provide them the records on a storage device. Another sort of associated question here was, well, what if the records that are being requested are already available online? Well, certainly, I'm sure the person who's making the request is going to be very happy to hear that. Because it probably means that they won't have to, you know, pay any copying costs. It's going to be a really simple response, and they'll probably get an answer really quickly. So I'm sure the person who's making the request is going to be very happy to hear that, but you want to make sure that you're not just ignoring the FOIL request. You should respond with a direct link to those records. Please don't just respond and say, those records are on our website, find them yourself. Provide direct links, because, you know, depending on the size of your agency, It may take somebody a long time to dig through and find what they're looking for. But if you can provide a direct link to the records that are being requested, that's going to make them very, very happy in most instances. There's going to be a couple of cases where maybe someone who does not have internet access, or someone who's just, not particularly tech savvy and would prefer not to have to access things online. If they're willing to pay copying costs, if they're telling you, no, I don't want to have to access them online, or I don't have the ability to access them online, I want paper copies, if they're willing to pay the fee, I think you need to do it. Again, this provision of the statute talks about if an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. So an example that often comes up is an individual makes a Freedom of Information Law request for a data report, a report of the type that the agency doesn't prepare in the regular course of business, but it's that it has the ability to do so. So it may not be a report that your agency cares that much about, so it doesn't really run those reports on in the regular course of business. But if your agency has the ability to query its database and extract the data that's being requested with reasonable effort, the law says that that's not the preparation or creation of a new record. It's just extracting existing data, and it is just making a copy of the data in a format that the individual requested. The applicant for records, there's not a lot of responsibility they have on their end, but the biggest responsibility that they have is, first, the law states that a request for records can be required to be in writing. That's not to say if you're a town clerk or a village clerk and someone shows up to your window and says, can I get a copy of last week's meeting minutes? It's perfectly fine for you just to hand over a copy without requiring them to put it in minutes. It's at your discretion. That is entirely within your discretion. But it is also within your discretion to require that they put the request in writing. The next obligation that the applicant has is that they have an obligation to reasonably describe the record sought. So that means, can you understand what the person's asking for? Are they using terminology that you're familiar with, or that staff in your office are familiar with? And the next thing is, can you locate the records that are being requested with reasonable effort? The answer to that question is likely going to be different depending on whether the records exist in paper form or if there are electronic records. As we move more and more to electronic record keeping, it becomes easier and easier to locate records based on different types of criteria. However, I'm going to go back one. I'm going to use examples of types of requests that may not reasonably describe records because they're requesting the type of request that they're making. The agency would not be able to locate the records with reasonable effort. An example is someone submits a Freedom of Information Law request to town government for copies of all building permit applications for individuals who wanted to add decks to their homes for the past 10 years. The likelihood is that's not how the town maintains its records. I'm quite sure that they don't have a separate file drawer for just people who wanted to add decks to their home. So the answer to that may be, we are unable to locate the records you seek with reasonable effort. However, if you submit a request for a copy of a building permit for a particular property owner, for a particular small date range, for example, I'd like all building permit applications that were submitted in November 2020. That reasonably describes the record sought because that's likely how you maintain your records. They're also probably maintained by property address, so you could find copies of building permit applications by property address. But the type of project, less likely. So it would be perfectly acceptable for an agency to say, listen, we're not searching for a needle in a haystack. We are not able to locate the records you're seeking with reasonable effort. Every agency that is subject to FOIL is required to appoint at least one. You can have more than one depending on the size of your agency, but should have at least one person who serves as the records access officer. And they're required, the agency is required to designate that person by name or by specific job title. So it may be our town clerk serves as our records access officer, our village manager or our village clerk serves as records access officer, whatever it may be, but the agency's policy should designate by name or by specific job title. Often it makes sense to designate by job title so that way it doesn't need to be updated if there's a change in staff. But the records access officer is the point person for FOIL. That doesn't mean that they have to do everything. It just means that they're the person who receives the FOIL request and starts the process of ensuring that the agency responds to the request within the time limit set forth in the statute. They have the obligation to coordinate the agency's response to the FOIL request. And one of the most important functions of a records access officer is to keep an eye on the calendar and to make sure that their agency is complying with responding to FOIL requests within the time limit set forth in the statute. There's certain points as you go along that you want to make sure you're complying with. Within the first 5 business days, an agency must do something with a request. Receive a written request for records, and within the first 5 business days, the agency should either provide the records sought, deny access to the records sought, state we don't have the records that you're seeking, and perhaps just say we don't have them, or if possible, maybe redirect them where you believe to another agency that may possess the records. That's a nice thing to do if you're able to do that. And the last option is if it's a larger request, if you need more than 5 business days to respond, the next option is to acknowledge the request and state you need more time. The law states that the way the law is written, there's an assumption that generally it should not be more than agencies should not need more than 20 business days past the date of acknowledgement to respond to a FOIL request. So 20 business days really is the rule of thumb, so to speak. But of course, there's wiggle room built in. The statute understands, the legislature understood, I believe, that when it was drafted, that there may be times when an agency needs more than 20 business days to respond to a request. If an agency needs more than 20 business days from the date of acknowledgement to complete the request, the agency has an obligation to provide a date certain by which it will respond, and that date must be reasonable under the circumstances. So if you receive a particularly large and complicated request and you think it's going to take your agency 6 months, you can advise the individual who made the request that we will respond on or before a date that's 6 months out and give an explanation as to why you need more than 20 business days. It doesn't have to be a really long explanation, but it just has to say something along the lines of, given the volume and complexity of your request, we need more than 20 business days. Given the volume of Freedom of Information Law requests that are pending in our office, we require more than 20 business days. Any number of issues. In the past 8 months, COVID's been an issue. Given our limited staff and giving our limited access to physical records, that might be something that has come up in the past 8 months that would delay an agency's response. If you need more than 20 business days, just be sure that you're giving a reason for the delay and give a date certain by which you plan to respond. It is our interpretation, the Committee on Open Government's interpretation, that the law does not permit repeated extensions. For example, an agency should not be bumping out their response time month after month after month. What they should be doing is, if they need more than that 20 business days, evaluating how long it's going to take and giving that date, instead of just repeatedly bumping the person out every month, because that's very frustrating for a requester to not have any real clear idea when the end is in sight. If a denial of access is issued by an agency, an applicant has 30 calendar days from the date it receives the denial to file an administrative appeal, and the agency has 10 business days to respond to that appeal. Email requests. I know I had a question that what the law states. I think sometime 10, 15 years ago, the law was amended to state that if an agency is able, it must accept requests by email. And someone had asked me, how do you determine if they're able to do it? Well, I can't imagine that there's any agency at this point, any government agency that does not have the ability to accept requests by email. The question of whether they have the ability to respond to requests by email is, okay, does the record exist in electronic format, and is it small enough that it could be sent via email? For example, some electronic records are too large to send by some government agency. I know the Department of State has limits on the size of files that can be attached. So once in a while, something might be too large to send by email. That's an example of a situation where they may not be able to respond by email, but they may be able to put it on an electronic storage device. Another example, perhaps, of an agency's inability to respond by email is it a record that's not easily converted to electronic format? If you have paper records and you're able to scan those records and convert them to a PDF or a TIFF or whatever it may be, well, then you probably have the ability to respond to requests by email. However, if you work in a very small municipality and you don't have a scanner and the records only exist in paper format, well, then you may not have the ability to accept requests, or you have the ability to accept the request by email, but you may not have the ability to respond to the request by email. It's going to be whether you actually have whether your government agency has the capability of responding. Not whether you want to do it, not whether it's your preferred mechanism, but you actually have the ability to do it. Do you have the technological resources to provide the record in electronic format and by email? Another thing to remember is that while an agency you're more than welcome to create a FOIL request form for the ease of your residents, to make it easier for them to submit a FOIL request, but please keep in mind that you cannot require that a requester use your form. As long as the applicant for records submits their request in writing to the records access officer, they've done their job. No records access officer, no agency should ever be bumping back a written request for records by saying, please first fill out this form. They're not required to fill out your form, and an agency should not be delaying response by even asking them to fill out a form if they've already submitted the request in writing. Appeals. An applicant for records has the right to file an administrative appeal in two circumstances. The first is an express or an affirmative denial of access to records. If an agency possesses a record that is responsive to a request, but it is being withheld in whole or in part based on one of the statutory grounds for denial, that's an affirmative denial of access, and that gives rise to the right to file an administrative appeal. So that denial of access should always include tell the person that they have the right to file an administrative appeal and give them directions about how to do so. It should provide a name or a title of the person who handles FOIL appeals for your agency and an address and hopefully an email address for filing those appeals. The other avenue, the other circumstance that gives rise to an individual's right to file an administrative appeal is when an agency fails to respond to a request within the time limit set forth in statute. And we refer to that, our office refers to that as a constructive denial of access. So if a FOIL request is submitted and 5 business days comes and goes and the agency fails to even acknowledge the request, that's a constructive denial of access. If the request is acknowledged and the agency states we will respond on before a certain date and that date comes and goes and the agency has failed to respond, that's a constructive denial of access. Another situation that we consider constructive denial of access is unreasonable delays. If an agency repeatedly bumps out responding month after month after month, and at some point the person who has made the request just believes that the delays are clearly unreasonable at this point, that is also a situation that gives rise to the right to file an administrative appeal. We have model language for filing those types of appeals on our website if anyone would like to look at that. So there's a lot of information on the next couple of slides. Always keep in mind this information is on our website. I may not go over every single one in any great level of detail, but these grounds for denial are on our website, and they're also included in your right to know, the overview document that we have. So quickly, these are the grounds for denial, and I'm going to go over some of the ones that frequently come up. The first ground for denial, and in my mind, it's one of the most important to really have a good grasp on, is this when records are exempt by statute. So while all government records, all records maintained by a government agency are subject to FOIL in terms of, do we need to even look at these? Are they disclosable under FOIL or not? There are many records maintained by government agencies where disclosure is governed by another statute. And if disclosure is governed by another statute, then they are exempt from disclosure under FOIL they are exempt from FOIL disclosure. Examples of this is someone emailed me a question earlier this week about, for example, medical records or health records maintained by a county health department. Right now, a lot of county health departments are dealing with contact tracing and COVID test results and things of that nature. And if a request to a county health department is made for any types of individual specific records about a particular person, access to those records is not going to be governed by FOIL. Even if the person making the request is the subject of the records, FOIL is not the appropriate mechanism for accessing those records. Generally, it's going to be governed by public health law, HIPAA privacy regulations. So access to those records is governed by a separate statute, and that's the statute you're going to want to look to when determining whether disclosure is appropriate. Other examples are student records. If you're a school district, access to student records is governed by FERPA, the federal student privacy statute. So FOIL really doesn't apply. Mental health records is governed by mental hygiene law. Autopsy records, access to those records is governed by county law. County operated 911 systems, access to those records are governed by county law. Social security numbers, all agencies are required to redact records that contain an individual's social security numbers because that information is confidential pursuant to public officers law. Attorney-client communications, if a request is made for email communications between a municipality and its attorney, where the attorney is providing legal, or the municipality is requesting legal advice and the attorney is providing legal advice, those communications are covered by the attorney-client privilege, and those are also, access to those records is governed by the civil procedure law and rules, not governed by FOIL. This past summer, there was a significant change to FOIL. One of the statutes that I frequently referenced when talking about records that were exempt by statute and where access was governed by a separate statute was Civil Rights Law Section 50A. Up until June of this past year, Civil Rights Law Section 50A made confidential all personnel records used to evaluate performance and employment of police officers, corrections officers, and paid firefighters. Those records were confidential pursuant to Civil Rights Law Section 50A. They were not available under FOIL. In June of this year, Civil Rights Law Section 50A was repealed. It's gone. There's no longer any confidentiality provision that applies to those records. Instead, access to those records is now governed by the Freedom of Information Law. Freedom of Information Law was also amended to address access to certain disciplinary records of those of police officers, corrections officers, and paid firefighters. So the Freedom of Information Law was amended to define what a law enforcement disciplinary record is. It was amended to provide guidance on what aspects of the disciplinary records must be redacted and which may be redacted. So, for example, things that shall be redacted from a police officer's disciplinary record, if they need to be disclosed, is medical history, home addresses, personal telephone numbers, personal cell phone numbers, email addresses, social security numbers, the use of an employee assistance program, mental health services, or substance abuse assistance services. Those are the types of things that must be redacted if records are being disclosed under FOIL, if disciplinary records are disclosed under FOIL. Then there are items that may be redacted. Examples of aspects of law enforcement disciplinary records that may be redacted are technical infractions, may redact records pertaining to technical infractions. So, an officer's uniform was dirty, their shirt was untucked, whatever it may be. There's a definition of what a technical infraction is that's contained in the statute. So the law was essentially, Freedom of Information Law was amended to include some guidance specifically relating to law enforcement disciplinary records. But backing up a little bit, the best thing to keep in mind is access to these records now reverts to the same rules that have always applied to public employees. So if you're a police officer and if someone makes a request for your employment history, someone makes a request for your copy of your resume or any disciplinary actions that were taken against you, access to those records is going to be governed by FOIL, just as if that request had been made about me. Another example of a ground for denial that can be asserted by an agency is when disclosure will constitute an unwarranted invasion of personal privacy. Examples of unwarranted invasion of personal privacy are copies of employment applications of somebody who is not hired to fill a position, unsubstantiated allegations of misconduct. So someone accuses me of misconduct as a public employee, there's an investigation, and they find that there's no evidence to support the allegation. If someone makes a FOIL request for those records about me, that my agency could withhold them on the ground that disclosure would constitute an unwarranted invasion of my personal privacy. On the other hand, if there's a finding of misconduct against me, those records would be required to be disclosed. If an agency maintains records that contain medical information, disclosure of that would clearly constitute an unwarranted invasion of personal privacy, even if that information is not governed by HIPAA it can be withheld on personal privacy grounds. Public employees' home addresses can be withheld on personal privacy grounds. Lists of names and addresses of natural persons, if that information is going to be used for solicitation or fundraising purposes. This is an example of one of the very few times an agency is permitted to ask why the applicant for records wants the records. Most of the time it's irrelevant, and an agency can't condition disclosure on an applicant's willingness to provide an explanation as to why they want the records. This is probably one of the very few exceptions. So for example, if someone submits a FOIL request to the town clerk for a copy of all names and addresses of residents who received dog licenses in the past 10 years, the town clerk may go to look at that request and say, wonder why this person wants this information. They have a couple of options. One is they can ask, or do you plan to use that information for solicitation or fundraising purposes? Maybe the person who came in and submitted the request drove in a mobile dog grooming van, and it's clear to the town clerk that the likelihood is that the person plans to use that information for solicitation or fundraising purposes because they just opened up a new mobile dog grooming business. If that's the case, if the records access officer, if the agency believes that the information would be used for solicitation or fundraising purposes, the request can be denied on that ground. If it's not clear why the person wants that information, the agency can request a certification from the applicant that the information will not be used for solicitation or fundraising purposes and will not be shared with a third party who would use the information for solicitation or fundraising purposes. A fairly recent amendment to the Freedom of Information Law was to include copies of mugshots as an example of a record which, if disclosed, would constitute an unwarranted invasion of personal privacy. Up until a couple of years ago, it was the opinion of the Committee on Open Government and of the courts that disclosure of that information would not constitute an unwarranted invasion of personal privacy. The law was amended a couple of years ago to include it as an example. And just as a side note, which many of us know at this point in our careers, if you're a public employee, public employees enjoy a lesser degree of privacy than others. You can obtain a lot more information about me as a public employee than you could about someone who works in private industry. Intra-agency and interagency material. And if an applicant for records is seeking internal communications, often that is emails. They're seeking emails between and among agency employees. If that information reflects a deliberative process, for example, if it's sharing advice, opinions, recommendations, impressions, intra-agency material shared solely within an agency, or interagency material, communications between two different government agencies that reflect a deliberative process, can be withheld on this ground. There's 4 exceptions to the intra-agency and interagency material. If you have communications between or among government employees that contain statistical or factual tabulations or data, that needs to be disclosed. That cannot be withheld. Instructions to staff that affect the public must be disclosed. Final agency policies and determinations must be disclosed. And external audits, including Office of State Comptroller audits, must be disclosed. So that's sort of a double negative there. You can withhold intra-agency unless that intra-agency contains one of those 4 types of material. We talked about this a little earlier. When an individual is denied, oh, I'm sorry, I wanted to back up a little, and I apologize. I lost a slide at some point. I realized I forgot to add it in. But I'm going to go back to small here. If you look up on the screen, you're going to see item E, records compiled for law enforcement purposes. This comes up with any local municipality that has a police department. This is a frequent issue that comes up when incident reports are requested, any records relating to a law enforcement incident. One of the frequent grounds for denial of access that is asserted when those records are requested is Section 87(2)(e), records that are compiled for law enforcement purposes in which, if disclosed, would cause some type of harm. And then the statute lists the types of harm that it envisions might occur. And it's a two-part test. So when an agency is going to deny on the law enforcement ground, it has to articulate both parts of the test. It can't just state these are law enforcement records. An agency can't just deny records because they're law enforcement records. They have to be categorized as law enforcement records, and the agency has to articulate the type of harm that would be caused by disclosure. One is if the disclosure would interfere with the law enforcement investigation or judicial proceeding. If disclosing that information would interfere with how the investigation is being conducted or how the judicial proceeding is being conducted. If disclosure of the information would deprive a person of a right to a fair trial or impartial adjudication, that information can be withheld. If the records would tend to identify a confidential source or disclose confidential information relating to a criminal investigation, that can be withheld. Or if the records contain non-routine criminal investigative techniques or procedures. For example, if a law enforcement agency has a standard operating procedure manual, most of that, if a FOIA request is made for that manual, to a large extent, it's probably going to have to go. It's going to be a public record. However, there may be aspects of that manual that sort of would give the criminal the keys to the safe, so to speak. It may, if disclosing that information would assist potential criminals in evading law enforcement, if it would give them information that would help them evade detection, something of that nature, that's the type of information that can be withheld. All right, so I'm going to go back. So, of course, I did not go over every single ground for denial that can be asserted. And, of course, if anyone has questions about any of the other grounds, that's what I'm here for. Oh, let me go back to appeals. Okay, so if a denial of access is issued by an agency, the denial of access must be in writing, and it must give a reason for the denial. The initial denial of access does not need to be overly detailed. It just needs to assert essentially one of the grounds for denial, one or more of the grounds for denial that applies to the records being requested. When the denial is issued, the applicant has 30 calendar days to appeal. The appeal should go to the designated FOIL appeals officer. Law states that the FOIL appeals officer is the head or governing body of the agency or the person or persons designated by the head or governing body. FOIL appeals officer cannot be the same as the records access officer. You cannot have the records access officer also serve as the FOIL appeals officer, and I'm sure that's obvious for many reasons. It just doesn't make sense to have the same person looking at it twice. You want fresh eyes looking at it. Within 10 business days of receiving the appeal, the FOIL appeals officer must either provide the records sought or fully explain the reason for further denial, or some combination thereof. For example, the FOIL appeals officer might uphold the initial denial with respect to some records, but overturn the denial with respect to others, and that's fine. You can have a mixed bag. But if you're going to continue to uphold the denial of access, that appeal determination must be more detailed than that original denial of access. It should really go into some level of detail explaining how the harm that would occur by disclosure applies to those particular types of records. It really should substantiate the agency's denial of access. And part of the reason for this is you want to make sure that the agency is on solid footing if an applicant decides to challenge the denial in an Article 78 proceeding. Just as a reminder, I don't see this happen very often. At most, local levels of government, but on occasion I do see it. I want to remind all FOIL appeals officers that the law does not contemplate a remand back to a records access officer. It's the responsibility of the appeals officer to review the records at the appeal level. If the FOIL appeals officer disagrees with the original determination and believes that disclosure is appropriate, it's the FOIL appeals officer's obligation to disclose those records. It is not appropriate for the FOIL appeals officer to remand the request back to the records access officer for disclosure by the records access officer. Excuse me, my voice is going a little. Let's see. I don't want to cut too much into your Q&A time, but I just want to quickly go over fees, but fees can be a complicated issue, so I'm going to just try to go over it quickly, but as thoroughly as possible. I want everyone to keep in mind that there are two fee structures in FOIL, and these two fee structures cannot be combined. You need to keep them separate in your mind. One fee structure is for paper photocopies up to 9 by 14 inches. If someone is requesting standard photocopies of records, the agency is permitted to charge 25 cents per photocopy, and that's it. End of story, done. 25 cents per photocopy. That is all the agency can charge. And then everybody says, wait, what about the 2 hours? What about the 2 hours? Throw the 2 hours away. If you are providing photocopies, the agency is only allowed to charge 25 cents per photocopy, end of story. Then we get to the second fee structure. Second fee structure is for photocopies larger than 9 by 14 inches, or more frequently, records in any other format, audio, video, PDF, data, record in any other format other than photocopies. That's when the second fee structure comes into play, and that's when the 2 hour rule comes into play. What the law states is if the records are not photocopies up to 9 by 14 inches, then you are allowed to charge, the agency can charge the actual cost of reproduction for all other records. And the law states you're allowed to consider a couple of things. And the most frequent thing that comes up is you're allowed to consider the salary of the lowest paid employee capable of preparing a copy of the record, but only if it takes at least 2 hours. A common example here is you have a request for data, and you need your staff IT person to sit at their computer and extract data. If it takes them at least 2 hours to extract that data, you can charge the requester that IT staff person's time, hourly salary, multiplied by the number of hours that it took them to perform the task. Another lower tech example is scanning. Someone says, I don't want photocopies, I want my records scanned. If you can scan just as easily as you can photocopy, and it takes only 10 minutes to scan the record, the likelihood is you're not going to be able to charge a fee. If it's a very large quantity of records and it takes 2 hours or more for you to scan the records, for somebody in your office to scan the records, that's when you can charge. You can charge the salary of the lowest paid employee capable of scanning the records. You can also charge for electronic storage devices, so if you need to put records on a thumb drive or a CD or something of that nature. Whatever that costs you, you can pass that cost along to the requester. If you don't have the technological ability to prepare a copy in office, sometimes this happens with maps and blueprints, or maybe video or audio. You don't have the technology in-house to do something. If you need to send it out to a third-party vendor, you can, whatever the third-party vendor would charge you, that's the cost you can pass along to the requester. I very frequently get the question is whether you can charge mileage. I don't think you can. I think you can only charge the cost of what the vendor charges you. I don't think, like, for example, if someone needs to drive to Kinko's with the maps, I don't think you get reimbursed for the mileage. The courts have never addressed it, but that's my personal opinion based on the language of the statute. And one of the most important things to keep in mind is you cannot charge for search or review time. So the amount of time it takes for you to locate the records You cannot, that's not a fee that you're allowed to pass on to a requester. The amount of time it takes somebody to review those records to determine rights of access and to apply redaction, that is not a cost you can pass along to the requester. I was the records access officer for the Office of Mental Health for several years, and there were many days where I sat behind a closed door inhaling Sharpie fumes, and I'm sure that the Office of Mental Health did not love paying my attorney's salary for me to be doing that, but they did, and that fee did not get to be passed along to the requester. Finally, enforcement. Enforcement, if a denial of access is upheld after an administrative appeal, the applicant has a right to bring a CPLR Article 78 proceeding in state Supreme Court. Attorney's fees and other reasonable litigation costs can be awarded in two circumstances. It's mandatory on the part of the judge when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. And it's discretionary on the part of a judge when the requester has substantially prevailed and when the agency failed to respond to a request or appeal within the statutory time. So again, here's some contact information from our office. Please keep in mind that anyone is welcome to contact our office by phone or by email. Whether you're a government employee, you're a member of the public, you're a media representative, whatever the case may be, anyone is welcome to call our office. That's our phone number. I gave you my direct email address at the beginning of the presentation, but in addition, we have an office email address. So for example, if you get a bounce back message from me for whatever reason I'm on vacation, keep in mind that our executive director also reviews emails, and you can contact anyone in our office by using that coog@dos.ny.gov address. All right, so I am going to stop sharing. And I'm going to, where am I? Okay, so now I want to just find my chat function, and I'm going to look to see if people have asked me questions in the chat function. Let's see. Someone asked about the muck rock soil request, and my experience with for people that are not familiar, the muck rock soil request started coming in shortly after Civil Rights Law Section 50A was repealed, and our experience with those requests, and after conversations with numerous law enforcement agencies, is that the requests that we saw did not reasonably describe the records sought. They didn't provide enough detail to allow the law enforcement agencies to locate the records with reasonable effort. In addition to that, even if the law enforcement agencies could locate the records, the process of gathering and reviewing those records was going to take a significantly long time given the broadness of the request. Now, that's not a reason for denial. If you can locate the records, the very fact that it's a voluminous request is not a ground for denying access. However, it would be a good idea at that point to have a conversation with the requester. If you look at a request and say, this is literally going to take me years to do, then it's a good idea to go back to the requester and say, I'm not sure you understand quite how voluminous your request is and quite how long it's going to take us to review this. We can't just turn them over in their entirety. There are things, we have to review these records. There are things that we're required by statute to redact, and it's going to be a very time-consuming process. So going back to the requester and having a conversation with them about perhaps trying to narrow their request specifically to disciplinary records of a particular officer or a very much shorter time period, those are conversations that I would certainly encourage agencies to have with the requesters, regardless of whether it was Muckrock or any other. We saw them coming in from other sources as well. That was one that was commonly received among all municipal law enforcement agencies across the state. But again, at a high level, it was our understanding that many agencies just didn't maintain their records in a manner that would have allowed them to locate the records being sought with reasonable effort. So those are my thoughts on the Muckrock request. Another question that came, when an agency does not maintain or possess a requested record, does the agency have a responsibility to inform the applicant of their right to appeal? Do they have the right to appeal? In my opinion, the answer to that is no. A statement by an agency that it does not possess the record sought, in my view, does not give rise to an administrative appeal because it's not a denial of access. In my view, a denial of access is when you say, well, we have the records, but we can't provide them to you for this reason or that reason. A statement that we do not possess the records or that the records cannot be found after a diligent search is just that. We don't have them. You can appeal all you want, but we're still not going to have them at the end of the day. What I encourage, like, for example, if an applicant for records called me and said an agency is telling me that they don't have the records, but I'm not sure that I believe them, or I have information which would indicate that they may have the record, I encourage the applicant to first, there's a provision in the statute that allows a requester to request a certification from the agency. They can request a certification from the agency that the agency does not possess the records or that the records cannot be found after a diligent search. So my experience as a records access officer working with the Committee on Open Government is a request for certification of that nature often triggers a second closer look. Because if an agency employee is going to sign their name to a document certifying that the agency doesn't possess the records, they want to make sure they're right. So it is often going to trigger a second look, in my opinion, in my experience. And it also, if the applicant has information which may assist the agency in locating records that they were not able to locate in the first instance, well, that's certainly something that they should provide to the agency. The agency wasn't able to locate the records the first time. It's possible that by the applicant providing some additional detail, that they can provide that and they can locate the record. But a statement, in my opinion, a statement that the agency does not possess the records sought or that they cannot be found after a diligent search is not a denial of access that would give rise to an appeal. A follow-up question was about sick leave or sick time taken, and my assumption is that that's relating to law enforcement or police personnel records or any public employees. But yes, information about sick leave and sick time taken, any paid time off, any records that reflect time and attendance about public employees is generally public information. If for whatever reason the document includes details regarding the nature of the illness, certainly that can be redacted, but the very fact that someone is taking sick leave, if you're a public employee, that's public information. Question is, do we have model letters that we can use for most of the responses? I don't really, because things are often so factually specific. If you ever need help with something, feel free, to contact our office, but generally, like, for example, if you're providing access to the record, that's easy. You can always just provide a cover letter saying enclosed are the records you requested. If you're denying access, my recommendation really just is to say, in response to your request for A, B, and C, enclosed are A and B, but C is being withheld on the ground that, and then refer back to the statute. What is the ground for denial that's set forth in the statute that you're asserting? If That's just what I would include in the letter. And if you're denying access, you want to make sure that you're including appeal rights, the information that's advice that they can file an administrative appeal within 30 calendar days and how to file that appeal, to whom it should go to. Let's see, someone asked if a copy of the presentation slide would be available for review, and if anyone would like a copy of the presentation slide, I am very happy to email it to you. Just shoot me an email. Also, I'm not sure, I'm not as tech savvy as I should be. It's possible that it's available for download, but probably the easiest thing to do would just be to shoot me an email, and I'm happy to send it to you. FOIL programs, I'm not aware of any other FOIL programs that are available for purchase in terms of helping the FOIL officer. I'm not aware of any. Let's see. Sorry, I'm just skimming you. This is an interesting question about copy of the handicap permit issued to a specific individual. That would include the, you know what, that's an interesting question. About, someone wants to know, so a FOIL request came in for a copy of a handicap permit issued for a specific individual. It does not disclose the specific person's disability or handicap. It's just that the fact that a handicap exists. My feeling is people put handicap tags in their windows, in their cars. It's sort of a public reflection saying, I have the right to park in this spot because I've been issued this type of permit. So I think it's the fact that the individual has obtained the permit and is putting it in essentially in their own personal vehicle in a publicly visible spot sort of waives their right, their privacy right with regard to, they're basically openly stating, I have a handicap, I have a legal right to park in this parking spot, for example, because I have a handicap. So I don't think that you'd be able to withhold on personal privacy grounds, but I'm going to keep a note to myself to follow up on that. And if I have any follow-up, I'll address that later. Let's see, keep going through my notes here. Yep, talking about sick leave as part of a police evaluation. You know, formally, even before the repeal of 50A, courts had held that time and attendance records of police officers were public. So even if it wasn't part of their evaluation, availability of sick paid time off information about police officers was available even prior to the repeal of Civil Rights Law 50A, so that information should be available. Yes, the question is, do you need to provide appeal language when you redact portions of response? The answer to that is yes. That's a denial of access, because the way the law is written is a record can be withheld in whole or in part. And with that presumption of access, if you have a record that contains both information that must be disclosed and information that can be withheld, you have to redact that record. You can't just withhold it in its entirety. You would have to redact it and disclose the redacted version. The redacted version is a denial of access to a portion of the record, and therefore you have an obligation to let the person know the reason for the denial, the reason for the redaction, and then again provide appeal rights to the person. And then it says there's a doctor's going back to the handicap application, has a doctor's diagnosis. That I think should be redacted, yes. If there's any information relating to this person's specific disability or diagnosis, that can be redacted. But the mere fact that the person has been issued the permit, I think would be public. I think that's all the questions I have right now. I'm going to try to, I want to make sure. There's one more thing I was going to ask people to do if they're willing. I'm going to, let's see, how do I do this? Oh, I'm going to open a poll, and this is voluntary. I'm just curious. I'm going to ask if I'm hoping that maybe people see it. It looks like some people are answering already. That's wonderful. You'll see what it is. I'm just curious as to who's taking the class. It's just for my own curiosity at it more than anything, and that might help me as I move forward and as I know who's mostly interested in taking these training classes. That way I can make sure that I'm focusing on what's important to the people that are taking the courses. So I'll just give everybody a minute more to complete that. And while that's going on, I'm going to go back to chat to see if I'm missing anything. Yeah, I don't think so, but as I mean, always please keep in mind, take advantage of our website. We try to keep the advisory opinions are a good resource. I'm not sure if I went into any detail about that earlier, but both Freedom of Information Law and Open Meetings Law advisory opinions are based, and what they are is they're legal opinions prepared by staff of the Committee on Open Government that take a set of facts that are presented to us by the person making the inquiry, and we apply either the Freedom of Information Law or Open Meetings Law, and sometimes both, to that set of facts, and we offer an opinion. For example, whether we believe a record must be disclosed in whole or in part. Sometimes we're offering an opinion as to whether we believe an agency's response is consistent with statute. But that's something you're always welcome. That's a service that we offer. And it's not just available to members of the public. It's also available to government agencies who are interested in making sure they're doing the right thing. So it's sort of a preemptive request for an advisory opinion as to whether a record should be disclosed or not. You can keep in mind too, like for example, a request for a formal advisory opinion takes a little time. I do try to turn them around as quickly as possible. I try to turn them around in about 2 or 3 weeks, depending on if I need more time, more information. That's going to play into how long it takes me to respond. But if you just have a quick question, you just shoot me an email. I'm very happy to, if it's just a quick question that doesn't really involve an in-depth analysis of the statute, then I can turn that around really quickly. Advisory opinions, as I said, do take a little bit longer, but if you just have a quick question, the likelihood is I can get back to you, hopefully within the same day, next day at the latest. Someone posed a question about, do I have any recommendations for when an agency cannot meet the 10 business days to respond to an appeal? And I understand that that's a very practical concern. While the statute doesn't address it, there's nothing in the statute that allows for an extension of time when an agency can't meet the 10 business days to respond to an appeal. I think particularly given the past 8 months, again, 9 months, wherever we are at this point, I think everybody understands that things happen, and sometimes there's valid reasons for delays. My recommendation is always to keep in contact with the person who made the request and try to be as honest with them as possible about the reason why the agency can't respond to the appeal. I think a common example is if there's an appeal of a constructive denial and the FOIL appeals officer gets that appeal, they may have nothing to work with because the original records access officer hasn't even issued an original determination yet. So they may have an entire series, an entire file box worth of records to go through, and it just may not be feasible for that to occur within 10 business days. So again, while I understand that there's nothing in the statute that allows for it, my best recommendation is to, for example, in that situation, acknowledge that you realize that the records access officer, that the agency did not respond within the time limit set forth in the statute, and that we are actively working on reviewing the records and getting to them to you as quickly as possible, try to give a date certain or very, very reasonable date certain by which you plan to respond. I think that's the best you can do. Again, sometimes even if the original records access officer did issue a determination, The volume of the records that need to be reviewed by the FOIL appeals officer may be so large that it's just really not reasonable. I know at almost all levels of government, the person handling both the FOIL request and the FOIL appeals, that's just one of many, many responsibilities that they have. And reviewing file boxes worth of records and making a determination on every piece of paper within 10 business days just may not be practically possible. And the best you can do is to notify the requester, let them know you are actively working on the request and on the review, and try to give them a very reasonable date certain by which you plan to respond. Someone asked if we have a sample FOIL form to use. We don't have a form, so to speak, but we do have sample language, a sample model language for making a FOIL request on our website. I think it's under I would like to in the drop-down boxes. And I think it's also, if you click on the publications drop-down box under your right to know, we have model FOIL requests, model FOIL appeals, model FOIL appeals when an agency fails to respond in a timely manner. So, all right, well, it looks like worked out just about perfectly. We're almost at the hour-and-a-half point, and it looks like I've gotten through all of our questions. I really very much appreciate everyone logging on today. It was great having you all here and being able to do this. Keep in mind, again, that I do plan to do this on a regular basis. I haven't scheduled it yet, but keep an eye on the website. I'll get it up on the website as soon as I have a date for my open meetings law presentation in January. And then I believe I'll probably plan to do another Freedom of Information law, which I'm sure you guys are not going to want to hear again, but if you want to share with friends and coworkers that you think this might be helpful, just let them know to keep an eye on our website, and I'll keep it posted as to when I plan to do these programs, and it'll be under our news heading. So I thank everyone very much for participating, for joining me today, and you all have a wonderful day. Thank you so much.